So I am very glad that Ed is able to join us today for the session. Thank you, Ed. Thank you so much. And over to you for the great topic, choosing the power imbalances in mediation. Over to you. And Ed was very excited to address you all today, and he's got some special opening phrase for the audience today. Yes, Ed, please go ahead. Thank you. Thank you.
Thank you, Harshita. Good morning, everyone. Vanakkam Chennai. I am very, very happy to have the opportunity to speak with you today. It is amazing that we can have this conversation from with such a great distance. But for the mediators, all of us who are mediators, it is very similar to our work. We always are dealing with parties who think they are great distances apart. So it will be my pleasure today to work with Harshita and to make the distances between us be very small. I have some topics that I would like to talk to you about, and I am also happy to answer any questions or address a topic that anyone in the audience may have. I will tell you just a moment about my work. I was very, very fortunate at a very young age, the age of 28, to discover my passion in life, my life work as a mediator. And I served as a state mediator for my home state of New Jersey for 4 years, as a federal mediator for the Federal Mediation and Conciliation Service in both Washington, D.C. and Detroit, Michigan for 10 years. In 1988, I had an opportunity to join the National Center for Dispute Settlement, and I worked with them for almost 25 years. And since 2009, I have been a private mediator, arbitrator, and fact finder. I'm very proud to say that all of my work over the last 45 years has been in the role of a neutral third party, mediator, arbitrator, fact finder, trainer, and even election officer. My work stopped being a job for me long ago. It has been a gift, it has been a labor of love, and it remains very important to me to share the experiences of my career and to learn from colleagues like yourselves. So this morning, I hope that we will learn from each other so that we can continue to do the work of mediators or peacemakers in our respective neighborhoods. So that's a little bit about my background. Harshita, where would you like me to start?
Are you able to hear me now?
Yeah.
Now,
yeah.
yes.
Yes. Okay. So we can do some questions, and then if the audience also have some questions, we can deal with it at the end of the session. So I assume that they're going to be passing on the notepad while the session is ongoing. And so we'll also get some questions at the end of the session, I believe. So why, Ed, why do you think it's important for a mediator to understand negotiation?
This is a very important question, and I find that in the United States, as I visit training programs, there seems to be a tendency that concerns me greatly, because some new mediators, especially some new attorney mediators, are feeling that there is a great distance between their job as a mediator and the central process of negotiation. They think that somehow the mediation process is something remote, something distant, something even above the negotiation process. And at least in the United States, we believe that the negotiation process is the most important part of dispute resolution. It is more important in many ways than litigation, than arbitration, than mediation. It is the core or central process of all of dispute resolution. And while there are many textbook definitions of mediation, perhaps the most compelling that I can think of is that mediation is an extension of the negotiation process. It is negotiations that are being managed by a third party neutral, a mediator. And the mediator's only job is, in fact, to make the negotiation process work, to do everything that she or he can do to help the parties to reach an agreement. So, understanding negotiation is absolutely key for the mediators because it is their job to make that negotiation process as effective as possible. I will just say that not too long ago, I had the opportunity to have some new mediators observe some work that I was doing as part of a request from the state government agency in Michigan. And at one point in time, in a very difficult set of negotiations, I asked the two spokespersons of the parties to come into my office away from their teams. And during that process, I said to them, I need you to have a very open, honest, candid discussion about what it will take to settle this dispute. And during that time, the parties did everything that I asked them to, and they were quickly, quietly outlining all of the terms they needed to reach an agreement. And several of the new mediators who were observing became very nervous, and they asked if they could see me out in the hall. So we left this room and we went out in the hall, and I asked them what the matter was, and they said, Mr. Hartfield, those parties are being very rude. They are talking by themselves. They are not involving you. They are listing all of these issues. And I explained to them, that's exactly what I needed them to do. They were having a very frank discussion, and we needed that discussion to be successful if we were going to have success in resolving their dispute. So negotiation, in my view, is the most important of all of the dispute resolution processes for the mediator to know.
Right. Thank you so much for that explanation. So what do you think are the most common forms of mediation in the US. Could you please
Hmm.
explain that to us?
Yes, I will try my best. I think there are three basic, most common forms of mediation here in the United States. One is called evaluative mediation. Evaluative mediation occurs when the parties to a particular dispute are really only interested in one thing. They're asking an experienced mediator to provide to them an estimate of how much compensation will be appropriate to resolve a particular dispute. They're asking a mediator who has done a lot of work in a field to simply come up with either a number or a range of dollars that he or she believes is the appropriate amount to settle the dispute. Their parties in this case are rarely interested in repairing the relationship. They almost always have chosen this evaluative form of mediation because their primary interest is, let's agree on an amount of compensation, and at that point in time, let's get this dispute settled, say goodbye, and not ever have anything to continue our relationship. So that's evaluative. The second form of mediation, which is popular in the United States, is called transformative. Transformative mediation is a process which has been made popular by the U.S. Postal Service, the government organization that employs all of our mail workers, our postal carriers. There are about 800,000 of those employees across the United States. And because that agency is so big, for many years, it had thousands and thousands of very, very difficult disputes. Many thousands of arbitrations were filed by employees against the Postal Service every year. And so the Postal Service came up with a process called transformative mediation. And in this process, the emphasis is on the parties having a good conversation, a good dialogue between themselves. In fact, it is more important to these people to be able to have a conversation than it is to necessarily resolve the dispute. Another aspect of transformative mediation that is unusual is that the mediator encourages the parties to do things like set their own ground rules, agree to a specific negotiating agenda, decide which issues they would like to talk about first, and decide how much time they would like to spend on each issue. So rather than the mediator managing the process for the parties, the mediator is encouraging the parties to manage their own process. And finally, the third and probably the most common form of mediation is called the facilitative model. In this model, the mediator is primarily concerned with helping the parties to reach an agreement. The mediator takes a very active role in setting ground rules, in managing the negotiation agenda, in deciding when to have joint sessions with all parties present, and when to caucus or to meet separately with each side. The mediator may go back and forth in what we call a shuttle style, but in the end, the mediator does everything that he or she knows how to do to help the parties reach an agreement. This is the most common form of mediation today in the United States, and it is used widely in the court system in both public and private mediation. So once again, Harshita, we have evaluative mediation, transformative mediation, and the most popular, the most common, facilitative mediation.
Great. So why do you think, or why is it believed that confidentiality is a cornerstone of mediation process?
It's a very good question. Very good question. And perhaps the best way to answer it is to compare mediation briefly with arbitration.
Great.
Right. In arbitration, as you know, and I'm sure our colleagues in Chennai also are aware, the neutral party is in fact very much like a judge. They take testimony, they enter exhibits into a record, they carefully observe a hearing, and in the end of the process, the arbitrator will write a final and binding decision. In North America, that decision is not allowed to be appealed to any court of law. The parties have agreed that they will abide by that decision. And unless there is some very, very specific violation of due process, the decision may not be appealed. In arbitration, the arbitrator is prohibited from having a private conversation with the parties. All meetings must be joint with the parties present. All conversations must be involving all parties, or at least their spokespersons, their counsel. However, this means that there is often a great deal of information about what's really causing the dispute, which may not get shared with an arbitrator. In mediation, it is almost universally accepted that the mediator will be meeting privately with both parties. If they meet privately with one party, they will definitely meet privately with the other party. And the purpose of those separate sessions, or what we call in caucuses, is to encourage people to open their minds and their hearts to the mediator, to discuss with the mediator where their flexibility is, where they have movement, what their real concerns or problems are. Most people are reluctant to discuss those things in great detail in front of the other side. However, when the mediator can meet privately with them, and the mediator is able to build trust with them, the parties are more likely to share with the mediator where they think the real problem is coming from and what they might well be willing to do to resolve that problem. They are more willing to discuss these things with the mediator if they understand that during the time that the mediator is meeting with them privately, if there is information that the parties would prefer is not shared with the other side, the mediator must, I emphasize, they must keep that confidential. The only time a mediator can share confidential information is if the mediator has the express permission of the other side to do that. Otherwise, what the mediator does is use the information that they have received from each side to move each party closer to an area of agreement without revealing what the confidential information is. A violation of confidentiality is often a fatal error for a mediator. All the attorneys will know and they will talk about it. That complaints will be filed. If one is dealing in workplace dispute resolution, all of the labor organizations or unions will know, all of the employers will know. And that mediator, for all practical purposes, will not be used again. So if people cannot trust, if the parties cannot trust that the sensitive information that they share with a mediator will be protected, they will not talk to the mediator. So this is why confidentiality is such a important, as you put it, cornerstone of the mediation process.
Thanks for that. I also have one other question related to the private meeting between the parties or between one of the party and the mediator, or what we call the caucus session. So do you also think that there is a possibility of restoring the pre-dispute relationship between the parties because of the caucus sessions?
Yes, I think it is possible in some cases. I like to refer to something that we call the trust transference process. In the beginning, I need to establish trust in me. I need to get the parties to believe that I will be impartial, that I will be fair, that I will treat them evenly, and that I will do everything I can to help them, including protecting their sensitive information. Once I am successful in accomplishing that goal, my second purpose is to get them to also trust the mediation process. First, they've trusted me, then I want them to trust the mediation process. I want them to see that I will enforce the ground rules. I want them to see that I will listen equally to them. I will pay attention. I will ask questions. I will treat them with respect. And once they see how the mediation process is working, then last but not least, I also want them to regain trust in the negotiation process, the process that they themselves can use to communicate on an everyday basis. And if I am successful in doing that, and if the parties want to go back to their pre-dispute relationship, it may be possible to restore it. It is not, obviously, possible in every situation. Sometimes the parties have damaged their relationship, and this damage has occurred over a long period of time. In mediation, perhaps we only have a few hours with them. Perhaps we have a day or two. It may not always be possible to restore the relationship that they had prior to coming to mediation. But you would be surprised how often, if one party offers a sincere apology to the other side, that can really be the key to causing people to come back together again.
I'm sure I've had this experience in the past.
I'm sure. Harshitra, I was thinking in between my last answer and your question about the caucus of a recent situation that happened that maybe I can share with our colleagues in Chennai.
Sure. So you have a scenario to share with us?
I do. I
Oh,
do.
great. Great. Go ahead.
So during this summer, we were contacted by a large government agency that was experiencing tension between its departments. And many people were very upset, and productivity was being impacted. There were some people who were not able to function and come into work. And a colleague and I were asked to interview all of the parties in this agency to first find out what the problem was, and then to make recommendations about how to resolve it. We ended up interviewing about 150 doctors, nurses, psychologists, psychiatrists, etc. And when the process was done, we assembled a report. We had a list of findings of what had caused the disputes, and we made a list of recommendations as well. We had signed an extensive series of confidentiality provisions in our contract, in memorandums, and in several different ways. So we had made it very clear to the agency that confidentiality was absolutely paramount. When our report was received, it turns out that the agency agreed with one of our findings that a particular individual was responsible for a great deal of the problem. And this individual subsequently was terminated by the agency and decided to file a lawsuit. During the course of the lawsuit, the judge in the case ordered the parties and ordered the mediators to turn over our notes of those interviews. We explained to the judge that we were bound by the ethical principle of confidentiality. We submitted to the courtroom all of our documents that were signed acknowledging our confidentiality privilege. And in fact, this judge was not familiar with mediation.
Oh, really?
Really, it's hard to believe. And as such, he ordered us to submit our notes or to be held in contempt of the court. And we explained to him that under no circumstances would we be releasing our notes. In fact, in keeping with our traditional practice, 30 days after the conclusion of our work, we had destroyed our notes. And I began to wonder if, for the first time in my career, I would be spending time away from my family in a jail. But fortunately, at the very last minute, some other judge was able to discuss with him the role of mediation and the importance of confidentiality. And I did not have to spend any nights in a jail cell.
Sure, I know how critical that is. I truly understand that situation. So do you think, given these scenarios, the mediators should come up with some brilliant ideas after having caucus sessions with the parties? Ideas of his own, maybe, leading to a settlement?
A very good question. I think that it's almost always a question of when rather than if.
Right.
My preference as a mediator is to encourage the parties to be responsible for giving suggestions about how to solve their issues as often or as much as possible. I think that there is a danger that if a mediator with good intentions decides to offer brilliant ideas or suggestions too early in the process, the parties themselves will not feel sufficiently involved or invested in the process. They will think that their ideas may be the best idea. So before I offer any ideas, even if in my heart I believe I have seen this situation before, I have encountered the exact same kind of fact situation, I want the other party to be responsible for attempting to resolve their own dispute. As we know, sometimes when a mediator comes into the room, the parties relax, fold their arms, and they sit back in their chair and they say, the mediator is here. Mediate me. And in their minds, maybe because they are not comfortable with conflict, they think that the mediator is responsible now for everything. And I think that under those circumstances, if a mediator offers an idea, the parties are likely to say, well, that's a good idea, but here's why it won't work. And until I get a sense that the parties have exhausted their ideas and they see what will work and what won't work, I prefer to hold back on solutions. Finally, I think when parties are convinced that they have no more ideas, then and only then, I think, are they the most receptive to the ideas of a mediator. Of course, some people will be cooperative from the start.
Sure.
But in a dispute where the positions are very locked, very fixed, I think that the best way to get parties to understand what will work and what won't work is to require them to come up with a proposal, a potential solution, and let them see what the reaction is.
Great. So when we primarily talk about power imbalances in mediation and power imbalances between parties in mediation, is it not more to do with achieving justice and equity between the parties in mediation? Or what's your take on that?
Why are you giving me such difficult questions?
Because you could answer those, and I know that.
Well, it's an interesting question because I'm not sure about in India, but here in the United States, there is a controversy. there are many new mediators, and they have very good hearts. But in their heart, they see themselves primarily as a champion for the underdog, for the side that has a weaker position in life or in negotiations. And they want to use the mediation process as a way to address that inequity. They want to help those who don't have many resources to achieve justice. They want to do something to improve the position of the underdog. And I am afraid that even though these intentions are very, very good, I am afraid that if we give in to those intentions, we will do further damage to the position of those who have no power.
Correct.
In my view, the job of the mediator is to balance the process, to make sure that the mediation process is fairly run, that both parties are treated with respect and treated equally, that both parties have due process, that both parties are able to tell their story and to be heard. But if I intervene on the side of the weaker party, why should the stronger party stay? So if it's okay, Harshi, I have a story that I would like to share with my colleagues in Chennai.
Please do go ahead.
So, do all of you remember? Some of you remember from the 1970s and the 1980s, the famous U.S. Secretary of State Henry Kissinger. Raise your hand if you do, please. Okay, some people. So, Henry Kissinger was a Harvard professor. He was chosen to be Secretary of State for Richard Nixon and stayed on to the presidency of Gerald Ford. He was known for his brilliant command of international relations and for some of his diplomatic achievements, most particularly the before peace treaty that ended the Vietnam conflict. So the story is told of how Henry Kissinger decided to spend his life once he retired after 1974. And the story says that 1 year after he retired, he invited people from all over the world, kings and queens, presidents and premiers, ambassadors and diplomats, to Washington, D.C., where he unveiled his most magnificent project, and that was the creation, the opening of the world's most important zoo, a collection of rare and exotic animals from all over the planet. This was one of the high society international events of the year, as his guests were invited to take a tour of the zoo. Each time they arrived at a new exhibit, one could hear a chorus of ah, as all of the assembled guests just marveled at his ability to have collected some rare and magnificent animals from every species. But when the group reached finally the last exhibit in this special zoo, there was just silence. People could not believe what they were seeing. They looked at each other. They were speechless because in the last cage lay a lion and a lamb.
Mm-hmm.
And people were wondering, how could this be possible? How could the mightiest creature of the jungle and the mildest, meekest creature lay together? The tour guide finally explained, we have made great progress with the lion and the lamb. During the day, everything is peaceful as people come to watch and people are observing the lion and the lamb. But each night, once the night has passed, when the zookeepers come the next morning, the lamb has been gone. There is no lamb. The lamb needs to be replaced with a brand new lamb.
Oh, uh,
And I think that this story for me has a very important lesson about the question of balancing power. In all of life, it is very rare indeed when the power at the table is perfectly balanced. The greatest single thing that a mediator can do to help those that do not have power is to offer them mediation and bring the people who have power together with those who have none. Because it's the one opportunity when they can meet on what will come closest to be a level playing field. If the mediator decides to try to balance the power in favor of the lamb, why does the lion, those who have power, ever need to come back to mediation? If those who have power are not only facing those who have no power, but also a mediator, we do not any longer have a neutral environment. And I believe that those who have power will say, I don't need mediation. I have all the money, the resources, the lawyers that I need to continue in the jungle of litigation, of lawsuits. Why should I ever come to mediation? And the greatest thing that I can do for people that I may care about in my heart is to bring them together with those who have the power so that there is the possibility of a good conversation. So that's why I think your question is so important. If individuals want to help the underprivileged, the impoverished, those who have no power, they should work as advocates for those people. It is a very, very important role. But once you take an assignment as a third party neutral mediator to attempt to help openly one side in their struggle against the other side, you lose neutrality, you lose credibility, and the likelihood is that those who have power will either leave or never come back.
right. That's a very great story. That's a great story. I mean, you kind of summarized the whole topic in one story, The Lion and the Lamb. We're not going to forget The Lion and the Lamb.
Harshi, I would be very happy if the audience has questions. Maybe with your help, I do my best to answer them.
Sure. Before that, I have one last question for you,
Yeah.
and then we can just move on to the questions from the audience too. So, where do you think exactly there is a downfall from a mediator to correct the power imbalance? So, what do you think as mediators we should improve in ourselves to work on power imbalances during a session of mediation? Any tips could be helpful,
Yes.
greatly appreciated.
I think, again, you're asking a wonderful question. Um, I think that it's natural and understandable for human beings to care deeply about other people. Mediators, so often, in my experience, are people persons. They care. They like people. They like to help in any way they can. But it's critical that we remember that when we are taking an assignment, a case, as a mediator, what our role is. Our role is to be impartial. Our role is to be unbiased. Our role is, to attempt to do everything we can do to get an agreement. And perhaps one tip is to be very self-aware
Right.
of a feeling that you're getting, that you want to help this poor individual, this poor group, this poor company, this poor employee, in an effort to improve the situation. But then to ask yourself, what is the best way that I can help them achieve their goals? And if you feel that you are leaning towards one side or the other, it's a good time for the mediator to call a caucus and maybe go take a walk and remind ourselves of why we're there. And so being very self-aware of what your feelings are in mediation, during mediation, is very important. Also, in many training programs, Harshita, they are emphasizing being neutral, but very few training programs have opportunities for people to talk about their biases. Everyone has a bias. Everyone has some aspect of their personality that they should be aware. And if a case comes in that is part of that situation, maybe we should recuse ourselves from accepting that case. Maybe we should not take it because it is likely that we will not be able to remain neutral. And if you will permit a short scenario, there was a situation in my office where an automaker came to mediation because the automaker was being accused of a very, very serious case of gender discrimination. And in this case, a woman was suggesting that her supervisor had been very, very inappropriate, physically inappropriate with her. They selected an attorney from our roster of mediators. In real life, his full-time job was he was a plaintiff attorney. And when he heard the facts offered by the plaintiff, he became so upset, so aggrieved on behalf of that individual that he forgot where he was. He forgot that he was acting as a mediator. And he began instinctively to cross-examine the auto company.
Mhm.
And the auto company was stunned that the mediator was acting this way.
Mhm.
And after only a few minutes, they all left the room with all their belongings. They came down the hall to my office and they told me that they were leaving. And if I ever even included that individual's name on a list of mediators, they would never come back and never use mediation again. So it's very, very easy for people, good people, to have what we might call hot buttons, things that really upset them.
Hotspots.
Yes. And it's very important that we are aware of our hotspots and what will upset us. First, we need to decide, can we take this case and remain neutral?
Yep.
And if we take it, we must be very, very aware of how feelings are emerging and do everything we can to manage those feelings so that we can remain neutral.
Sure.
I think that's the best I can do right now.
Great. I mean, that's a very good scenario that explains it all about neutrality, about imbalances, in a nutshell. Great. That was a great session, Ed. I think we can move on to some questions from the audience. They're
Very
going to
good.
talk. They're going to ask you directly. I think they have
Okay.
some arrangements made there, so they're
Very
going to
good.
ask questions directly. Good. Thank you.
I'm looking forward to it.
Yeah.
Who would like to ask the first question?
I see some mic going around there.
Good morning, sir.
Good morning.
I'm sure that most of us should have experienced negotiation skills, especially after hearing. I would like to know what would be the good quality of a mediator. I would like to know what would be the good qualities to be maintained by a mediator.
Okay, so Harshi, did you hear the question clearly?
Yes. So he is kind of asking what could possibly be the good qualities of a mediator.
Okay, excellent. Okay, thank you. Every once in a while, the sound will be interrupted a little bit, so I had missed a little part, but now I understand. So here are the qualities I think are important for a mediator. Number one, to be able to be a good listener.
Great.
To be a very good listener, to actively listen, and to be able to listen equally to all parties. Number two, to be a good communicator verbally, to ask good questions, to listen carefully to the answer, to do everything we can to keep a conversation going. So good listening, good verbal skills, to be very trustworthy. When you are promising confidentiality to the parties, you must look into their eyes, and they must be the only people in the world. They must hear what you are saying in their hearts, and you must mean it. And to be patient. Harshitra asked me before about, is the mediator's job to come up with brilliant solutions? It's very possible that early in the process, you may have an idea or two exactly how to settle this particular situation. I encourage you to be patient, to encourage first the parties to offer their ideas. And then, when it appears that they understand that those ideas will not work, to find the right time or place, most likely a separate session, to say, what if you did this? Have you considered doing this? So, good listening, good verbal communication, being very sincere, being very present in the moment. When people are talking to you, you must not have your phone out, your calendar, the newspaper, or any other business. You must be listening to and carefully caring about what they are saying. They have to feel that you are paying attention to them. I think at times it may be helpful to have a good sense of humor, to lighten the tension and to make people relax, and also to not be afraid to smile and to let people see your heart. I think those are some of the qualities that I think are very important. For me, the interpersonal qualities, the interpersonal skills are much more important than a degree. Many of my colleagues at the Federal Mediation Service were individuals who had spent their livelihoods working in factories. They knew people. They knew how to talk. They knew how to listen. They knew how to communicate. But they didn't have the degree. But they were the most effective mediators often to resolve a dispute. I hope that's a helpful answer.
Yes.
Sure, it did. Thanks. We can move on to the next question if someone has a question from the audience.
During a caucus, does it raise a suspicion? During a caucus, does it raise a suspicion? And it's not to help.
It's a good question. Here's how I would do it. Here's what I would do to avoid suspicion. Number one, in my opening statement to the parties, at the beginning of the mediation, I explained to people that during the course of the mediation, I will definitely want to meet with each side privately. I tell them why I am going to do that. I tell them about my promise of confidentiality. And I ask if they have any questions. Then, when I make the decision during the mediation to call a caucus with one side, I will again tell everybody in the room, it is now time in the process for me to spend some time meeting separately. First, I'm going to meet with Mr. Jones. I will take about 10 minutes. Again, I remind you, the reason why I'm doing that is, and then when that's done, I will meet with Mr. Smith. And then when I get into the caucus and the door is closed and I'm meeting privately with one side, I tell them, look, I very much want to help you. But if you do not share with me what's really going on in this case, I am very limited in what I can do. If you share with me, I must keep anything that you are asking me to keep confidential, I will. So all of that is my answer to you is to say, I tell them about the caucus in the opening statement, and I tell them I will be caucusing with both sides. I tell them before, again, I begin to caucus with either side. I remind them during the caucus that I'm going to keep things confidential. And so during the mediation, I take at least 3 or 4 times to explain this to them carefully. And then sometimes, depending upon the kind of case it is, And especially if it's my understanding that the participants are coming to mediation, when my office would send out the confirmation letter in advance, I would include this information in writing to them up front. I may even give them a 5-minute video to watch when they come into the office, so that this concept of the caucus will be reinforced. Recently, at a meeting here in Detroit with a group of professionals like yourselves, an attorney who is a family law professional asked me the very same question. Doesn't the idea of holding the caucus, having this separate meeting, run the risk of creating mistrust? And I told him, if I cannot meet privately with either side, why do they need me? They're good, they're lawyers, they are professional negotiators. They have tried a variety of techniques. The one thing that I have as an advantage is that mediation allows me to and encourages me to meet privately with both sides. And if I am successful in that private meeting, I can gain insight from each side as to how to solve their problem. Once they understand that, I think the risk of causing mistrust is smaller.
Thank you. Checking if there's any more questions.
Okay.
Can I? Yeah, good morning, Mr. Edward.
Good morning.
Yeah, I have a suggestive procedure. In continuation of the interesting story you explained to us, lion and the lamb. So
Yes.
two scenarios. What is barbarian scenario where lion will eat out the lamb? When it comes to a mediation, we can say the lion has a very good case on merit and the lamb doesn't have any case at all. That is the second scenario. The third scenario, lion will have enough money power to litigate till the end, but lion may not have a meritorious case. On the contrary, the lamb will have a meritorious case, but doesn't have any money power to litigate. So when this is placed before a mediator, the mediator will know the lamb, out of fear of expenditure to be spent for litigation, agreed for a settlement. How will you evaluate the settlement?
Another very good question. I think that it's one of those situations. I cannot give you a formula. I cannot give you a recipe that will work every time. I think that sometimes we mediators have to look at that lion-lamb situation and ask ourselves, what is realistic? What is possible? And sometimes what will happen, if we believe that the lion and the lamb are destined to walk in the same jungle, in the same meadow every day, then our view of a settlement may need to be changed. Maybe we have to establish a safe zone for them to walk together. Maybe we need to take a long-term view of the building of their relationships. Maybe we need to look at this as the first of a series of conversations. Maybe we will have to bring in other lambs or other lions. So if we focus on evaluating only a settlement at the moment, the real question we must ask ourselves is, what will help these parties in the long run? And to see if we can build a foundation where that one lamb and that one lion, or their groups, can coexist. And it may require us not only to have a different view of the settlement, but to take a long-term view of a mediation process that is designed to encourage many conversations. I hope I have answered your question somewhat.
I'm sure that's a great explanation.
Yes, it's a very good explanation. We really appreciate. But one aspect is when you evaluating the settlement, as a mediator, we are not going to make any mistake. We will be neutral, but we will know the lamb had sacrificed to cover up the fear of future expenditure in litigating the matter. So in that scenario, though we know that lamb can have better settlement if they litigate, if it litigates, but because of its fear of litigation expenses, we know that lamb is losing, but still a settlement is a settlement. We have to agree.
Okay. Harshi, I'm sorry, I missed some of the words there due to the sound. Did you understand?
Yeah, a little bit. I did miss a bit too. So basically, he's just trying to say, just with the fear of litigating, the lamb has agreed to a settlement and taking up the mediation process. Yeah, I mean, that quite happens most of the times, and people have to accept reality given their situations. So let's see if we have any other questions, or we could just move on to wind up the session.
That's it.
Okay. All right. Thank you so much, Ed. I'm sure I've actually worked with Ed on several projects in the last couple of years. And today he just mentioned about how a mediator being a people's person. And I'm sure that very, very much applies to Mr. Hartfield. Because on various projects that we both have worked with, I've seen a lot of our colleagues talking loads and loads of good things about him, both professionally and personally. So that is something that Mr. Hartfield has earned over the years of being that people's person. And it's always a pleasure working with him. And I believe we would continue on several other projects in the future. Thank you, Ed. Thank you so much. Thanks for your valuable time. And it was a great workshop, and your scenarios were absolutely great and very easily understandable, I would say. Thanks a lot.
Harshita, thank you for the opportunity. Thank you to our colleagues in Chennai. And as I close, I would like to close and to say to them, Nandri, thank you very much.
So to be a mediator, After observing you, we saw three qualities in you. To be a mediator, after observing you, we realized there should be three qualities. One is a great smile. One, second is a very soft body language. Third is being very, very presentable. Thank you, sir, for sharing your time with us. It has been a immense pleasure and a learning experience for all of us. Thank you, Ashita, for making that happen.
Thank you, sir. Thank you so much.
We'll be encountering you in the later part of time also. Thank you, sir.
It's an honor. Thank you. Nandri.
Thank you. We'll see you all soon in the next session. Thank you. Bye.